Ladies and gentlemen, we are just under 4 minutes to the start of our live stream and presentation to the Waterways residents.
Welcome, everyone. We're going to get started on the formal part of our evening. So if you're interested in hearing and seeing the presentations, I'd encourage you to come into this side of the room, cross the curtain, and have a seat. So my name is Brenda Erskine, and I'm the Director of Communications and Stakeholder Relations for the Regional Municipality. And I'd like to welcome you to the third specific Waterways Here For You session. And our focus tonight is to provide you with updates on some outstanding questions and concerns. I'd like to apologize on behalf of the municipality for the amount of time that's passed since the last session, and then for putting it off for one more week. We wanted to have some solid answers for you, and sometimes the political process takes a little bit longer than we expect it to. As usual tonight, we have a number of presentations lined up for you. What isn't usual is how we're going to end the presentations. Usually we have a question and answer format, live streamed with microphones and all that stuff. And tonight we want to do something a little bit different. When you came in the door, we asked you what brought you here, and we put your answers up on Post-it notes. And then what we're doing is putting those Post-it notes into 4 themes. If there's more than 4, then some of those other themes we'll have to deal with at another time, or we'll answer those questions specifically online. But the 4 themes will then be centered into tables in the room on the other side of the curtain, and we'll have facilitators and we'll have experts to address each of those themes. And the idea is that it creates more conversation. You learn from each other. You ask questions of each other. You ask questions of us. We'll have people wandering around who can answer questions that maybe can't be answered at the table. It's meant to be a little more informal, a little more engaging. And we know that some people don't necessarily like getting up in front of the microphone and being live streamed. And we're just hoping that this is a better way of engaging you. And if it's not, you know what? Feel free to tell us, and we'll take that feedback and we'll do something different next time. Oh, the other thing I should mention is that for the online audience, obviously they don't have the ability to participate in those facilitated group sessions afterwards. So what we're asking them is to send their questions and comments into the recovery@rmwb.ca email, and we'll put that slide up at the end. If you don't want to participate in the group tables at the end, nobody's forcing you to. As I said, there will be people walking around. There'll be people at the various tables, so you can do that as well. So with no further ado, I'll introduce our first presenter, and I won't introduce each presenter as they're coming forward, so please introduce yourselves. All right?
Thanks, Brenda. My name is Dana Woodworth. I'm the wildfire recovery team leader here for the RMWB. And I just want to take a couple of minutes to cover a couple slides, but most importantly, I want to let you know that I want to echo some of Brenda's comments. The decision to delay a week was deliberate, and it was a conscious decision on our part to actually be in this position with information that we think will actually provide you more certainty versus we picked a date, we thought we'd be through a certain amount of policy consideration and have decisions made. Well, we weren't there. So I can understand and I empathize with the actual reality of moving that date back. Not desirable from our position as well. But I feel more confident that today, that we're here now with more fidelity, more information, more facts, and that'll be a more productive discussion with you. So I want to share that with you. I'm going to cast our minds back in time to early September, and I want to briefly discuss some of the major actions to date. And I want you to understand that there has been and continues to be a focus and attention on waterways. We recognize within the RMWB that your community is more complex and frankly has more hazards associated with it than, and I will say it, than Abbotsand or Beacon Hills. I get that. We understand the complexity of the flood hazard area and then the pattern of the fire that took out your houses and in your community. So we've always known it was going to be a tougher policy conversation and harder thinking. And that doesn't mean that we haven't been doing that. It just means it takes time. I want you to know that. So September 8th was really our initial Here For You session. And we came at that time with what we thought, we framed really broad ideas to you. And at that initial engagement, we were actually given some feedback. And the vast majority of that time did come back with a preference for a rebuild, which is what we had heard anecdotally, and it's what we heard at the first Here For You session. But you also raised a new concept of a buyout, which was put on the table at that time, and we took it back to consider. The September 27th, and this is again part of the process of democracy, you know, and how your government works. Waiving of fees was brought forward to Mayor and Council, was discussed, and it was actually tabled and approved, and there'll be an upcoming slide that will talk about the development and permit-related fees that were actually waived. And all of that was done with the intent of alleviating some of the financial pressures that we know you're under collectively. Then we went to the repeal of the flood-proofing bylaw, which was really a flood hazard zone bylaw 16021. This repealed bylaw number 13032. So it removed for you the flood-proofing requirements. It allowed you to develop in the flood hazard zone that you were positioned in with less restrictions. Make it easier is the intent to rebuild and to come back to your community. Now the areas below the 250-meter elevation were also subsequently captured in the wildfire recovery overlay area, which is a planning and development tool which will be discussed. It repealed a certain section that prohibited any building being below the 248-meter contour. So again, it was about certainty and about providing you an easier way to come back to your community in a timely manner. Rebuilding in the floodway or flood fringe is a risk. We know that. We all do. So in that tent, there was a waiver created to acknowledge that risk and a save harmless agreement and to register it on title. That's all I'll say about that, and certainly David will have more details for you on the actual logic, the rationale, and the intent of the waiver. The extension of the overlay, the bylaw into the Waterways flood hazard area, was introduced as Part 11 of the land use bylaw. It applies to the wildfire damage areas, including Waterways itself, and it repealed 0736. So a very, quite frankly, a quite old bylaw was repealed. And it was much, again, in the same line as Abbotsford and Beacon Hill. It was about providing you with a degree of certainty so you can make decisions that if you were to approach planning and development with a certain build design, that you would be approved. So it goes back to the concepts of discretionary and permitted uses. And the intent was and is to give you more certainty and more flexibility and easier way back into your community for rebuild decisions. And that will be discussed again here at greater length. We're back on October 13th. We had a Here For You in its exact location, a very similar format. And we talked about the updates, the changes from that point in time till then. And we also had some conversations. We tried to further explore what the thinking was around buyout in a separate room. Flood mitigation will be covered in a separate slide. It's a fairly comprehensive topic in itself. The flood hazard area, the risk to your community, obviously predates the wildfire. It's not a new risk or a new concept for you. And we will let engineering here, Ray will talk about it shortly, and give you the current situation with respect to how mayor and council and the government want to mitigate that risk for you. I'll go to the next slide. So, what else has changed since we last met? Well, the demolition is complete. So the debris removal, which took some time, is substantively complete, which sets the conditions for rebuild. And I will say this from my experience. Many think that the debris removal in the front end of disaster recovery is the most complex. It typically is not. We are right now entering what is typically the most difficult phase for the residents, for those affected by the disaster, for planners, and for government to make decisions. And I want you to know, the reason I say that, if you think back to debris removal, and some would say it was haphazard and it was, looked a little ill-coordinated. But the reality was we had fewer contractors. So the overall prime was spec, and the ability to limit the number of contractors who were in that physical space working made the debris removal simpler. It's not the same, not quite the same when you do the rebuild, because you have your individual choice, and that will be respected about who you hire to rebuild. So typically the coordination challenges associated with a rebuild post-disaster in any community are tougher. I just want you to know. It doesn't mean we ignore it, and we're doing some thinking, some hard thinking around how to coordinate the regulatory aspects so that we rebuild your community in a safe manner, an efficient manner, and a compliant manner. The re-entry of the standing buildings, October 24th, that was a long-awaited point in time. The Chief Medical Officer of Health lifted and allowed re-entry for the 33 standing buildings. As of now, you have over 350 permits have issued for rebuilding, 160 housing starts, and 9 of those in the waterways areas. Slope stability will be discussed in more detail on a follow-on slide. And as I indicated earlier, the waiver concept and the details around it will be discussed in a follow-on slide. So the last piece I want to turn my attention to and give you some clarity on, hopefully, is the council decision on flood mitigation. Many of you who attended the September 8th meeting here, to Hear For You, you asked that floodproofing not be included as a requirement and simply be allowed to rebuild. So we listened to that, and we thought about concepts around collective mitigation of an area versus point mitigation of a house, and do you need both? And discussions around, do you need a belt and suspenders or one? And at that time, and still, the overarching sentiment from the community, the overarching sentiment from your government was to set the conditions for you to rebuild. So the belief was you don't need suspenders and belts. We're going to try and set these conditions to give you the broad, area-wide flood protection. So we removed the floodproofing on that premise. We had sound documentation from the government of Alberta, which gave a fair bit of clarity on what they would provide in terms of disaster recovery programming fallback, if in case there was a flood that breached a 1/100 level. So it wasn't done in a manner, we'll just take this risk haphazard. We had been in close correspondence with the government of Alberta, and they had reassured us in writing about some of the tools that would be in place if we built to a certain level. So subsequent from that initial conversation about the type of wall that would be considered technically sound, how would you actually achieve a guarantee for disaster recovery programming, we've actually received even greater clarity and simply the statement that if you build to the current 1 in 100 elevation of 250 meters, even if it changes, they will grandfather and respect that decision that was made in the moment. So all of these decisions occurred since we met last here, and all of them have added greater certainty and greater confidence in the policy advice and decision making of your mayor and council. That's enough for me. I'll turn the floor over to Ray.
Thank you very much, Dana. And good evening, ladies and gentlemen, and thank you very much for coming out this evening on a rather cold Fort McMurray evening. My name is Ray Cruikshank, and I'll just adjust my notes. My name is Ray Cruikshank, and this evening we're here to bring you information about flood mitigation for waterways. Work on flood mitigation has been ongoing and continuously moving forward, and here are some of the updates. On the first slide, this Tuesday, December 13th, Regional Municipality of Wood Buffalo Council passed a motion directing administration to advance flood mitigation development. In particular, 4 strategies will be going forward simultaneously, and they are: the first one, proceed with the pre-design, the design, and construction of flood mitigation to a 250-meter elevation with a serious look at a demountable wall structure. You're going to hear about 250 meters and 248.5 meters, and this is just a shorter way of saying the height above mean sea level. So 250 meters is 250 meters above mean sea level elevation. This height of 250 covers the requirement for a 1 in 100 year ice jam flood event. Also, at this height, the provincial government has stated eligibility for the disaster recovery program will be maintained. And as Dana just said a moment ago, if, for example, a greater than 100-year flood should occur, or if, for example, the qualification should change to something greater than 150 meters. The second motion that Council passed, still on the screen, is that administration would make allowance for additional 1 meter height in the design to have flexibility for the future. Now initially, 248.5 meters was sufficient, and after the 2013 flood, the provincial government required a 1 in 100 year protection, which, as you know, is this height of 250. Although the government has assured us that the 250 meters is enough and will be grandfathered, we want to be prudent, and we want to construct a strong enough foundation for the findings of the new government report, which is expected in 2018. So we want to do enough and then more. On the second slide, I think we'll see that the third strategy approved by Council this past Tuesday is to provide temporary measures up to 248.5 meters until the permanent measures are in place. The temporary measures can include a variety of things, such as sandbagging, inflatable tubes, pushing earth for temporary dikes, and so on. It's important to note that any elevation already at or above 248.5 right now is expected to withstand a 1 in 40 year ice jam flood event. The fourth motion that was passed, or the fourth part of this, was, in addition, we have gained the approval to rent ice breaking equipment in the 2017 flood season. Now, as you probably already know, and I think most people do, a common cause of flooding is ice jamming. And the ice piles up in big sheets along the river, and then it blocks the flow of the water from proceeding downstream. Ice breaking equipment, used successfully in Winnipeg, for example, smashes the ice into smaller pieces that do not jam, but continue to move downstream. I've actually personally seen this equipment in use since 2009, and it's pretty amazing, and it really works. It's very effective. Moving on to the next slide. This map shows the planned alignment for the 250-meter flood structure. For description, we illustrate 11 reaches, so just one reach after another, lengths of flood protection. Starting at the left side, we see reach number 6. Reaches 1 to 5 on the left, further left, which would be off the screen, are further downstream along Prairie Loop Boulevard. So let's take a look here at the reaches that are on the screen. Number 6 comes around Prairie Loop Boulevard. Number 7 parallels Franklin. Number 8 comes behind Longboat Landing. And number 9 backstops the lower town site. Now, moving on to what's probably a little more interesting, reach number 10 runs around Ptarmigan Court, so there's various pieces there, and it also parallels the Saline Creek Parkway up to Park Street. And last, but certainly not least at all, is reach 11, which parallels Saline Creek Parkway out to Draper Road, at which point we will already be at the 250-meter elevation. Moving on to slide 4, next slide, for me it's 4. A number of flood mitigation measures have already been put into place, as has been mentioned. The work done reflects the 1 in 40-year flood level, which was previously the accepted level. We're now moving forward to target the 1 in 100-year flood level. Flood remediation work after the June 13th flood increased the level of protection along the Hanging Stone River. Construction of Saline Creek Parkway is now providing a 1 in 40-year flood barrier, parallel to the Clearwater River. And investigations into options for getting to the 1 in 100-year level are being studied, including such things as a demountable wall structure. In the end, the best solution might be a combination of structures, including berms, permanent walls, demountable walls, for instance. Okay, moving on. Why is this interest in demountable walls? Well, it was understood from the community engagements that an unobstructed access and view to the Clearwater River is important, and I couldn't agree more. The demountable wall, placed on a grade level foundation, can provide that access. It can be constructed to a variety of heights, with posts and slats that are removable when not in use, leaving only the grade beam, which would be set at grade level. It may be the only option where it's there when you need it, and it's not there when you don't. So I'll move on to the last part that I have here, which, moving forward, we have the provincial government and council agreement of the elevation to use for further design, and that being 250 meters. The next step is to develop specifications for engagement of a qualified system designer. In addition, we will conduct a thorough geotechnical investigation to determine the structural capacity of the existing geology. And with these first 2 steps, the structural viability of various options can be calculated. We will continue to bring information, seek your opinions, as more information becomes available. Thank you very much for your interest and attention.
If I could just ask Dave LaFleur to come to the front, please. Dave LaFleur. Thanks, Dave.
Next slide, please. Oh, okay. Sorry about that. No problem. Yeah, much better for me to look at one in front of me here. Okay, so I'm here to speak a little bit about the conditions of development approval that are being required in the flood hazard zone of Waterways. Now, first of all, emphasize not all of Waterways, as you all know, I think, Not all of Waterways is within the flood hazard area, right? So those portions that are, where there were houses that were destroyed by the wildfire in those areas, when it comes time for you to apply for a development permit to rebuild, which you do require, okay, that is a requirement for a development permit. I won't get into the legal reasons for that, but under the Municipal Government Act, the level of destruction was sufficient that you do have to get a new development permit to rebuild. Okay, so you're going to come in and you're going to apply at the development at the planning department for a permit to rebuild, and you're going to find at that time that you're going to be asked to sign 3 different documents, and they're sort of like conditions of getting approval. Okay, so you get approval provided, well, there may be other conditions of approval as well, but I'm only going to talk about these documents. So there are basically 3 of them. They're a waiver, a development agreement, and a restrictive covenant. And I'm going to talk, first of all, generally about why any of these are even required at all, and then I'll get a little bit into the specifics of what each document does. And I must also point out to you that if anybody is interested, we have at the back table tonight, we have hard copies of each of these documents, and we also have a separate little document we prepared, explanatory notes that will, so you have something in writing to look at. Sorry, I'm not speaking loudly enough. Can everyone hear me now? I guess it was more for the sake of the TV cameras. So, okay, appreciate that, Aaron. So, as I was saying, we have here tonight copies of each of the documents and also a separate document called explanatory notes that sort of explains what each document is, what it does, and what it's intended for. So, as I said, first of all, just a couple of general comments. As Dana has earlier said, and as you all know, the flood hazard area of Waterways is called that for a reason. Historically, it's an area that is prone to flooding arising from ice jam floods on the Clearwater River. They don't happen every year, as you know. Sometimes you'll go 10, 20 years without one, but you know that at some point, it's not a question of if, it's a question of when the river will rise high enough that if there was no measures taken to hold the floodwaters back, there would be flooding in those areas. Houses would be flooded, okay? That's just a matter of historical record, historical fact. So, looking at that, we, as a municipality, we said, okay, what is the situation we now face? Before the fire, the majority of houses, maybe all of them for that matter, that were in that flood hazard zone were very old houses. They dated back decades. Some of them originally built before there was planning legislation, before there was such a thing as development permits. They went way back. They were effectively very much grandfathered. They would be allowed to stay there, and if there were a flood, there wasn't really any risk that the municipality could somehow be liable for the damage because those houses had been there so long, they were just a fixture. The fire changed everything. The fire changed everything, I'm saying, from a perspective of the municipality's perception of its own risk. Because now, once the fire had destroyed, let's say, the majority of homes, which I believe is true in the flood hazard area, the municipality had to ask itself, okay, what would happen if we allowed rebuilding? And if there was a flood with major damage, would we as a municipality be held liable for having basically allowed people to walk knowing into a trap, as it were, being to rebuild an area that we knew was risky? And so, to be very frank with you, at very early stages after the fire, there was a certain amount of discussion: should the municipality even allow rebuilding there at all? Very quickly, I have to tell you, very quickly, our council came to the conclusion that even though perhaps it would be, if you're only looking at the question of risk to the municipality, if that were your only concern, maybe it would be best to not allow rebuilding. But our council quickly came to the conclusion that, you know what, that's not by any means the only consideration. Far more important is that that's your home. And if you want to rebuild your home, we should facilitate rebuilding your home, not try to make it difficult. So that was the rationale for some of the measures that Dana talked about, changing bylaws, repealing some bylaws, making it legally easier removing obstacles to rebuilding. At the same time, though, there definitely was a concern that if that happens, and then if a flood occurs and, millions of dollars of damage occur, we don't want to, as a municipality, want to be held liable for something that we're trying to do to facilitate you getting back in your homes. And as a result of that, the concept arose that, okay, perhaps we should ask those people who are going to rebuild, ask them to acknowledge in writing that there is a risk to doing that, accept that there's a risk, that they're taking that risk, that they're not going to come back on the municipality later on. The thinking then continued from that. The thinking was, okay, if we do that, what kinds of documents could we ask people to sign now so that both the current owners of properties would not have a claim against the municipality if there were a flood, which they knew would happen, but also that potentially future owners of properties would not be able to say, well, the municipality, you're liable for allowing rebuilding. And so that's where the three documents came from. They came from considerations like that. So I guess there's another thing that I need to emphasize, which I know I did talk about at the previous Here For You that I spoke at, and I'll reiterate it again. The law says that municipalities, even though they may not have a legal duty to do physical things to mitigate your risk of loss, or to lessen your risk of loss, it's for sure, and this is Supreme Court of Canada talking here, we have a duty to warn. We have a duty that if we're aware of a risk, we have a duty to be sure that those who might suffer damages because of that risk are at least made aware, are at least warned that this is the risk, okay? And that would include not only people who have lived in Waterways and lived there at the time of the fire and still own property and rebuild and want to rebuild now, it would include potential future purchasers, right? We can't pretend that the same people who live there now are going to live there for 5 years, 10 years, 15 years. Everyone knows properties do change hands. So we had to consider how could we meet our duty to warn people of the risk, not just those that live here now, but those who might be interested in purchasing at some point in the future. And so with all of that in mind, these three documents were developed. The waiver, I'll deal with that first. The waiver is not a document that's intended to or will be registered on anybody's title. It's simply that you who are here now, you are asking for the development permit now, you who own the land now, who are rebuilding now, you are being asked in this waiver simply to acknowledge that you understand and agree that this is a risk and that if there is a flood in the future, you won't make a claim against the municipality for having voluntarily taken the risk of building. It's as simple as that. You could, the document is couched in somewhat legal language, but that it really boils down to exactly what I've just said. The other two documents, the development agreement and restrictive covenants, are both intended to protect the municipality against potential legal liability for having allowed rebuilding in that area, but in couple of different ways. The development agreement basically is agreement you sign now, but it goes on your title, and therefore any future purchaser would be bound by that agreement. It's not very onerous in my view. It doesn't require you to pay any money at all. It basically says that you will just render whatever reasonable assistance the municipality requires, and I can't predict what that might be. It might be something as simple as, allow heavy equipment access across a corner of your property for a week or so during construction. It could be something as simple and basic as that. But it would be primarily, though, the purpose is to say that if the municipality, not if, when the municipality gets busy and actually starts constructing things such as Ray described, that you won't come back or your future purchaser, whoever it might be, won't come back and sue us for disturbance, for nuisance, for noise, for dust. And the reason we're asking you to do that is very simple, because we're hoping that everyone will agree that if the municipality does construct serious flood mitigation to hold back the waters from even a 1 in 100 years flood, that's an enormous benefit to your property. That's a huge benefit. It enhances both the livability of the property and the market value of the property. So we basically are saying, please don't come back and make a claim against us if during the construction phase things are a little bit noisy or messy. It's as simple as that. The restrictive covenant is a little more far-reaching, but it has the same idea in mind. It basically says, look, when you're developing, when you're rebuilding your property, please bear in mind that the municipality also owns quite a lot of property in waterways, right? All the roads, the parks areas. We're asking you to be sure that when you redevelop your property, you refrain from doing certain basic things that could increase the risk of flooding of municipally owned property. So the two that are most important, and again, you can read the document for yourself, we don't want you to alter the grade of your existing property in a way that lowers the grade or promotes the flow of water onto municipally owned property. And we certainly don't want you to cover more than a certain minimum percentage of your property with hard landscaping. In other words, leave enough part of your property where water can soak in, that it doesn't just automatically shed off onto neighboring properties. We don't believe that those are particularly onerous requirements, but both of these documents, both the development agreement and the restrictive agreement, also serve the function of, because they're on title, any future purchaser is going to do what every prudent person does. They're going to search title, see what's on title. Is there a mortgage on there? Is there a utility right-of-way? And it serves the function of warning a future purchaser that this is a flood hazard. I see there's a hand waving. I just have one last thing to say. This is probably the most important thing I'm going to say about this topic, is that we also, we looked at the whole situation and we said, look, when flood mitigation measures to the 100-year level are fully implemented, whether it's a wall or a berm or, as Ray mentioned, some combination, when we're satisfied that we've taken those measures to have a decent level of protection to a 100-year flood, do we still need to keep those things on your title? Now, to be honest, if we were totally focused on just eliminating all risks to the municipality, we'd probably keep them on your title indefinitely. But we've made a decision, and we've announced to the public, and I'm repeating here again now tonight, that we believe that when the flood mitigation measures are in place, the risk to the municipality, although there will still be some, will be small enough that we can confidently take those encumbrances off your title. And that is the intention, okay? I can't, I'm not an engineer. I can't answer if you ask me how long that will take. I do know that there is an intention to get after this work, get after the design, the approval. I think council approved getting after the design right away. So first you design, then you procure materials, then you construct. It's a big project, but it's not being delayed, right? There's money approved by council to get going on it right away. So I think that's very encouraging. So that's basically all I wanted to say about these documents.
Can you tell the people behind us to be quiet? It's very difficult trying to hear this gentleman and trying to concentrate on this gentleman.
Should I start from the beginning?
Extraneous noise going on behind us.
Okay.
And I'm sorry, I'm missing a lot of what you're saying because
Okay, well, I'm sorry about that, and hopefully we can fix that. But I do want to emphasize, though, as I said before, and maybe it's partly I'm not close enough to the mic. That probably was better. Please go to the back table, take copies of these actual documents, and most importantly of all, we've created a document that kind of explains in layman's language all of what I've just said. So if you haven't been able to hear quite well enough everything I've said because of the background noise, you won't go away with nothing. Okay, so okay, fair enough.
Thanks, David. And for the questions, I know some of you may have come in later and missed the announcement, but we're not doing Q&As as part of the presentations. David will be available afterwards, and we will have the 4 tables with facilitated sessions set up, and I'm pretty sure that one of those tables is going to be around the legal waiver and the things that David just spoke about. So bear with us, and that will happen afterwards. Thanks.
Thanks, Brenda. Good evening, everyone. My name is Erin O'Neill. I'm the operations manager for the Recovery Task Force. So I'm just going to talk to you about a couple things tonight. So the first, we've been hearing a lot of questions about overhead and underground utilities being reinstalled in waterways. So electrical service in waterways is provided by ATCO Electric under a franchise agreement that they do have with the municipality. Now, overhead was selected as the path forward early on in our recovery period for a number of reasons, and these are actually in the order of why we selected them. First, the possibility of rebuild delays as a result of switching to underground. The time it would take to facilitate that underground design, and we'd also need to obtain some additional utility right-of-ways to actually facilitate that, and then the overall cost implications. But the main reason behind that was the delay in time that would be experienced, and we did hear that to move forward with the rebuilding, and we did want to encourage that, so we were able to facilitate the overhead utilities. Can I have the next slide, please? So we did talk to ATCO Electric extensively about what would it take, what's the timeline it would take to do underground services. So they are continuing with the overhead right now. They are almost complete. They'll be complete in the next couple days. And underground could take up to 14 to 16 months to complete. So as opposed to delaying the rebuild through that period, we are going ahead with overhead utilities. It will be complete shortly. But what we are going to do is we are going to look at a revitalization plan for waterways. We're going to investigate that possibility of can we revitalize, can we potentially in the future, in the next 3 to 5 years, do that revitalization project for the deep shallow utilities, so water and sewer, some of the other municipal services that are under not up to municipal standards of the right now, some of the back lanes, sidewalks, those types of things. So we will be looking at that overall revitalization plan in the coming months, and we will be engaging residents on that to see what their views about that and if we should proceed with a revitalization plan for the community over the next 3 to 5 years in waterways. Let's have the next slide. So the other thing you've heard about, back in September 8th, there was some questions. As you know, in that Cliff Avenue area, there are some slope stability and geotechnical concerns. And as a result, when you go to get your development permit, you are required to submit geotechnical reports. There was questions about when I apply for my new rebuild permit, do I need to submit those? What impact has the fire had? So what we did is the municipality did an overall slope stability, or doing an overall slope stability geotechnical report for that area. So the objective of this is to do a detailed assessment of what we refer to as the Clearwater River Valley slopes, specifically in that waterways area. That will allow us to recommend any possible mitigation measures and recommend any setback distances that will be required. The assessment is currently in progress, and the report will be submitted by the end of January. So we did do a visual inspection in September to see if there was any major concerns. What we mostly saw was there was not major concerns, but we did break that area up into specific areas that I'll show you in a map later on. So just next slide, please. So as I mentioned, it is a requirement of the land use bylaw to identify any slope concerns when you're building on a slope. So this will not take away the requirement specifically for a geotechnical for your certain property. It may take away that requirement, but there still may be a requirement. What this will do is it will provide that overall assessment of the area, and it will likely decrease the cost of any geotechnical that you'd be required to do, because a lot of that information that would be looked at for the overall area will already be done by our geotechnical advisor, and that report will be available in January when we have the results back. So the next slide just shows you the areas that we looked at. So based on that visual assessment that I mentioned in September, the areas were broken up into area A, B, and C. So there was no evidence of recent post-fire instability or excessive erosion during this area based on our visual inspection. So area A is the area of Tomlinson Street to Huggard Street, and due to the close proximity of properties to the steep lower slope, the steepness of the slope, and the significant degree of the tree burn in this area, area A was considered to be a high priority area requiring further detailed investigation. So there's drilling going on, installation and monitoring of slope in that area so that we continually monitor that area. Now area B, which is the Huggard Street to Park Street area, so also due to the proximity of the development to the slope, the height and the steepness of the slope, area B was also considered high priority, and we are also doing geotechnical drilling in that area. Now area C, which is the Cote Bay to the Tomlinson Street area, does have a lower slope area. It does have digressive degree of burn, so that it's considered to be a lower priority for that area. It will require less intensive investigation, but there is going to be ongoing monitoring of that area. So with that, I'll pass it over to Planning and Development to answer some of those questions.
Thanks, Aaron. My name is Jamie Doyle. I'm the Director of Planning and Development. I'd like to speak to you a little bit tonight about the area redevelopment plan as well as the land use bylaw. Because these documents are so complicated and there are a lot of questions, we do have a table in the back where we can sit with whomever and have a conversation about some future planning of waterways or some bylaw requirements. Waterways is included in the City Centre Area Redevelopment Plan in section 5.5.8. This policy provides some direction to allow for a mix of low-rise forms of housing while encouraging some mixed-use commercial development along Bullia Avenue and Railway Avenue. Planning, through consultation, will work towards implementing updated zoning as part of the larger land use bylaw amendment process. So we will be coming out to the community and talking about the land use bylaw, and this new bylaw is what implements that section of the ARP for waterways. Next slide, please. The municipality is currently in the process of resurveying Abasand, Beacon Hill, and Waterways. On-site investigations for waterways are complete, and the information is currently being compiled and drafted into a plan. The municipality is also working with the province to reestablish survey monuments that were destroyed or that are missing. Through the cleanup process, many of these monument pins were lost. The municipality is also in the process of working with the province through the Minister of Environment and Parks and the Director of Surveys to reestablish these survey monuments. Next slide, please. To date, planning has received 15 development permits in waterways and 9 permits have been issued. With that, I'll hand it over to Aaron again.
Thanks, Jamie. So again, just for the record, my name is Erin O'Neill, and I'm the Operations Manager with the Recovery Task Force. So the next slide, we're just going to talk about buyout. So as Dana mentioned earlier, in September 8th, the residents did put forward, through an informal survey that we did, they wanted us to consider the possibility of a buyout. So Mayor and Council's decision on December 13th to do a long-term flood mitigation strategy implies that there will be no buyout of any of the properties within the flood hazard area as a flood mitigation strategy. The Recovery Committee and the task force will not be entertaining buyouts with residents within the flood hazard area for our ongoing engagement, planning, and rebuild. And this motion the council made on December 13th, so this past Tuesday night, that did set the final conditions to allow residents to rebuild in a timely manner. So it provided the certainty that was outstanding if flood mitigation was going forward. So now that that certainty is available, we have removed buyout as an option because it's not feasible to do both a buyout and flood mitigation. If I can have the next slide, please. So rebuild plan, we are actively working on an actual tactical rebuild plan. So in Waterways, there was 226 properties destroyed by the fire. And as you can imagine, the coordination of rebuilding all of this at one time is a challenge. Now, this is not, it's not as though it's new for Fort McMurray to develop this number of homes in a year. But what's different in this instance is typically we're doing new subdivisions or what we refer to as greenfield development, whereas this is infill development, so there are different challenges with residents living in the area, commercial properties being open, all those types of things. So it presents a challenge in all of our destroyed areas. So what we've created is an actual rebuild plan, and one of the main factors of this rebuild plan is what we're referring to as a construction management team. So that construction management team will have specific coordinators for each area. So the Waterways area will be combined. The coordinator for that area will look after Waterways, Anzac, and Sapere Creek, and they'll be there to do all things such as work with the contractors of the coordination of delivery of materials, work with homeowners if they have questions, and work with our enforcement team to say there's a concern here, or I noted this here, or the haul routes are not being used, or the construction routes are not being used. So we'll really have that coordination, so that person really becomes an expert in the Waterways area, so they can coordinate that whole rebuild given the challenge of rebuilding in this area. Next slide. So the last slide that I'm going to talk about is, as Dana mentioned earlier, we would give you an update on the fees. So at the September 27th council meeting, council made a number of motions on fees. So some of those are that council waived all development and building permit related fees for properties damaged or destroyed by the wildfire. Now, if you go into planning and development, apply for your permit, your fees are automatically waived. If you apply online at this point, you pay for those fees, and then a check is issued to you within 6 to 8 weeks. For anyone that already paid those fees before this program in place, those reimbursement checks are being mailed out to residents. Council also approved that night a rebate for concrete. So when all this destruction happened, the landfill did become the owner of a lot of concrete. So we were able to crush that concrete, and the intent is to be able to use that concrete for future infrastructure projects. So because we were able to gain that asset, we are actually giving every resident, regardless if you had a foundation or not, a rebate check in the amount of $540, and that will be issued back to the property owners within the coming weeks, because we were able to gain that asset that we would have had to purchase. So now that we have that asset, we are returning that to the residents. Council did also approve excess fees for fire break homes. So fire break homes are considered any homes that were demolished prior to the ignition of the fire to act as a fire break. So a lot of these residents, upon clearing their properties, they did experience excess fees at the landfill because they weren't taking ash and debris to the landfill. They were actually taking larger pieces of structures to the landfill, so it was more expensive. So we have approved we want to make those people whole again, so they're on the same status as other people. So there will be rebate checks issued for those people, and if you'd like specific details about what those rebate checks are, we can answer those after, and we will be advising residents in the next week or so what those checks will actually look like. As I mentioned earlier, the geotechnical underway. That overall geotechnical the cost of that is being covered by the municipality. As Jamie mentioned, the monument pins or survey pins, which many people refer to them as, that cost will also be covered by the municipality. Now, that will not negate the need for you to do site planning or surveys for your property, but it will decrease the cost of that overall, because those survey pins will have been reestablished by the municipality. And that grading plan that will allow you to apply for your permit, so we can understand that all properties have positive drainage, is also being undertaken by the municipality to decrease the overall cost to the residents. And with that, I will pass it over to Sarah. Thank you.
Hi, and thank you for your patience and listening tonight. My name is Sarah Morant. I'm the Manager of Stakeholder Engagement for the Recovery Task Force. I just have a couple of quick updates and around the commitment that not only myself and the team of people that work with me have, but the commitment our council, the Wood Buffalo Recovery Committee, the task force as a whole, and our entire organization have to engaging residents whenever it is possible. We also recognize and understand that public engagement is not a one-size-fits-all field. There's not ever going to be one style of engagement that will reach every single resident and meet your needs perfectly, which is why we do aim to have a variety of different techniques, try to change things over time, and again, we're always open to your feedback on what that looks and feels like. Engagement, as it's practiced through the International Association of Public Participation, which is IAP2, has a spectrum that ranges from inform all the way to empower. So an example of inform in the engagement spectrum would be what you're seeing tonight. This is an information presentation. If we stopped it right now, you've been informed. And an example of empower on the other side of the spectrum would be when a governing body, for example, were to hold a referendum, where a community would make a vote on a decision, and that use of empowerment is used when the decision impacts all or the majority of taxpayers in a region. So that would be something to think of on the empowerment side of the spectrum. Some of the engagements that we've had and the techniques we've used to date include the Here For You sessions, of which we've now held over 30 of them. The trade shows, multiple trade shows, home shows throughout the season, different stakeholder meetings, so more targeted focus sessions with specific stakeholders that are impacted by any one plan or decision being considered. Community events, we've taken the Here For You campaign alongside countless community events to bring some more information, gather your feedback, listen to your questions in many different ways as we can. We've recently launched the call to the community to apply for focus groups. Again, another opportunity to have some targeted feedback into recovery operations. Online, we have through social media, through the website, of course, the recovery@rmwb.ca email address. Of course, by phone, you can call the Pulse line. We did have telephone town halls for the duration of the summer into the early fall. And of course, we do encourage direct conversations. Our staff have them on a regular basis with many residents to gather feedback on many issues. And my last slide is just a reminder for our online audience who are watching through the Facebook live stream that we are encouraging you tonight to send any questions, comments, feedback about any part of this presentation to recovery@rmwb.ca. We have a commitment to you that any email you send will be responded to in the duration of this session. So between 4 o'clock and 8 o'clock tonight, all of your Waterways specific emails that you send will be responded to. So it's thanks to our dedicated team that are on call to respond to those right away. We have heard from many, maybe some people here, maybe some of your friends and neighbors, that they don't like the idea of asking their questions on social media because everyone sees their name. And some of these questions are very personal in nature, and they would rather have more of a targeted one-on-one conversation, and an email seems to be a better way to start that conversation. It also ensures that you've received the information you need. Because if you ask a question on social media and something pulls you away from your device, your smartphone, your computer, we don't know for sure if you've received the answer. So we would much rather this method. It's an opportunity for us to ensure that you get the information you need. So thank you to the online audience. And again, it's recovery@rmwb.ca. Thanks. I'll pass it to Brenda to finish things off.
Thanks, Sarah, and thanks to all of our presenters tonight, and thanks to you, our audience, as always, for showing up, because this wouldn't be very successful without you. And now to the next part, which I'm hoping will be successful. So the winning key themes that you gave us. So the tables will be set up, one for waiver and encumbrance, no surprise there. David LaFleur will be our expert at that table, and I'll be facilitating. There'll be a table on engagement and communication, and Sarah Morant will be our expert at that table. I'm not sure who all the facilitators are. There'll be a table on flood mitigation, and I suspect that Ray will be the expert at that one. And there'll be a table on land use planning and engineering. That's kind of a few key themes and a lot of specific questions that we put into that. So there's a bit of a mix there. Some of the themes that didn't make the cut were, one was frustration. So whoever is frustrated, I'll ask you to go to the table with the theme that frustrates you the most, or go speak to someone individually. Why no buyout? If the presentation didn't answer your question, I think it might be best if you spoke to someone from our recovery committee. Marty's here. Sorry to put you on the spot, Marty, but Marty Giles will be here, and you're welcome to ask him some specific questions, or again to participate in one of the tables on another theme. One of the other ones was can't sell our land, which we weren't quite sure where we should put that one. So if you feel like you belong somewhere, please join us. And if you don't, please seek someone else with a municipal lanyard, or go to the general recovery table. And the other one is kind of similar, rebuild, yes or no. We've provided a lot of answers, I think, to help you make that decision. We certainly can't make that decision for you, but if there's a specific table, again, waiver and encumbrance, engagement and communication, flood mitigation, land use planning and engineering, hopefully you can find a table that helps you make that decision. All right, so at this point, you can get up and move to the back and maybe grab a coffee or a cup of tea or a glass of water and a cookie and a piece of cheese, and join whichever table you feel is most appropriate. And by the way, if you pick a table and then you think, oh, this one's not going anywhere, feel free to get up and move. You're not forced to stay in the same place.